Can an attorney withdraw from a case for mental or health reasons without proof? Okay, there are two ways to look at this. So an attorney wants to withdraw. If this is not a legal matter presently in court, then you don't need to get any court's permission. And usually an attorney can withdraw as long as they give enough time for the client to find another attorney to take over the case. For example, you can't do it right before a deadline as an attorney. But attorneys have a right to withdraw for mental or health reasons usually, as long as they do it in the right way and with enough time. You might say, well, what is the right way? And what is enough time? For that, we would look to the laws that govern the attorney's license. They're usually called the ethics rules. Every state has ethics rules that govern attorneys. And so you would look at the withdrawal from representation of a client section of the ethics rules. But usually what they say is an attorney can withdraw as long as it's not prohibited by law and as long as the attorney gives proper notice. And frankly, sometimes attorneys just aren't getting along with clients, or the clients won't take the attorney's advice, so the attorney can withdraw for that or other personal reasons. Now, if the case is in court, then the question is, do court rules require the judge to give permission for the attorney to withdraw from the case? As a general rule, courts require the attorney to get permission from a court. This is true in most criminal cases. This is true in most federal courts. This is true in many civil courts in various states. In Minnesota, if there's not an upcoming deadline and it's a civil case, usually the attorney can simply withdraw without the court's permission. That assumes the attorney is doing it for the proper reasons as provided in state ethics rules. Is it okay for an attorney to withdraw from one client for mental or health reasons, but not all clients? Assuming that state rules and court rules do not prohibit an attorney from withdrawing from a specific case or a specific client, usually the attorney can withdraw from a client's representation for any reason or no reason. It could simply be, I don't have enough time, or the client and I have conflict, or I don't believe I can do the best work for this client that the client deserves, or other legitimate reasons of that type. What are illegitimate reasons? Well, you can't say, oh, I don't like the client's skin color, or I don't like the client's religion. That's discrimination. You generally can't do that. There's certain protected classes for discrimination. But for non-discriminatory reasons, generally an attorney can withdraw for other reasons, and that means withdrawing from one client where there might be a lot of conflict, turmoil, or stress, and not from other clients. There was the question of whether an attorney has to provide proof of health or mental health reasons when withdrawing. Usually there's no proof required unless a court or a specific ethics rule requires it. That proof might be simply a statement under oath from the attorney, so it may not be outside documentation. But it is possible that the attorney would need to provide additional detail, like I recently consulted with this licensed medical professional who has given an opinion that I should withdraw from this case. Or the attorney might provide medical records of some sort. Or the attorney might provide a statement from the medical professional that says they need to withdraw. Judges have a lot of flexibility in what they can require of attorneys based on the specific rules for state or federal court. So the short answer is, generally an attorney can withdraw without proof of mental or health reasons, but all of this is subject to each state's attorney ethics rules and any courts where that attorney is currently appearing or on file. The attorney will need to follow the court rules and any requirements issued by the judge in that case. You are welcome to subscribe to our little reminder email system at aaronhall.com/free. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. As I always say, Before you rely on any of this, consult with an attorney. It's my hope that you use these questions to identify topics and questions to bring up with your attorney. I hope you are doing well. Take care.